this is what I think, this is where you want to talk to me. That, under this court's decision in Lane, is what any government official can do in their personal capacity.
So that means President Trump's Twitter account was also personal?
Yeah, I think that was a harder question, Your Honor, because there was, in that case, use of a government staffer to help him run the page.
Suppose that there wasn't. Suppose that, he gave every indication of writing his tweets himself, and suppose he had also posted them, so there wasn't a staffer involved.
Yes, Your Honor. Then I think that he is engaging in his First Amendment rights under this court's decision in Lane to talk about the government in his individual capacity.
But he seemed to be doing, a lot of government on his Twitter account. I mean, sometimes he was announcing policies, even when he wasn't. I mean, I don't think a citizen would be able to really understand the Trump presidency, if you will, without any access to all the things that the president said on that account. It was an important part of how he wielded his authority. And to cut a citizen off from that is to cut a citizen off from part of the way that government works.
So a couple of things about that, Your Honor. The first is President Trump could have done exactly the same thing from Mar-a-Lago or a campaign rally. If he gave every one of those speeches at his personal residence, it wouldn't somehow convert his residence into government property. And in terms of people being cut off from it, people don't have a right to access other people's personal property. The blocking here doesn't turn on...
It seems a little bit, to focus on the wrong end of the stick, if you will. I mean, the fact that it was his personal property seems neither here nor there. If really he was doing government on it and wielding his authority on it and announcing policy on it, and it was part of the way government operated.
Well, so here's why I don't think that's quite right, Your Honor. Imagine he had put on his page a clear disclaimer. This is my page that I'm using in my personal capacity to talk about the government. This is not an official page. Every single word on that Twitter account could have been the same.
Right, but why shouldn't we require that then, if you're right? In other words, it seems to me the problem that we're having is, even if we agree with you that government officials can operate in their personal capacity and in their official capacity, why should they get to choose whether or not they're doing one or the other without, say, making a clear disclaimer or making it clear to people that this is actually happening in their personal capacity?
So I'll give you two reasons, one conceptual and one practical. The conceptual reason is because the First Amendment generally doesn't compel speech. It generally protects against compelled speech.
Yeah, but you can't have it both ways. I mean, to the extent that we know and we agree with you that the person can operate in one or the other, I don't understand why it would necessarily be a compulsion to have them do so clearly.
So because what is basically being said is, if everyone agrees my clients could have said this in their individual capacity and had First Amendment rights to do so, but they will lose those rights unless they put up a disclaimer, that is basically saying...
No, I'm not saying they'll lose the right? You can go down road A or road B. You have the freedom to do that. The question in this case is, how do we know which you have chosen?
Right, and so the disclaimer is essentially a condition that is being required to go down row A rather than row B. That is an odd thing to say that the First Amendment of its own force compels. Let me also give you a practical reason why this is the right way to think about it. You're setting up a trap for the unwary. There are lots of government officials in this country. They're probably not all going to read this court's decision. And if you adopt a rule that the only way they can exercise their rights under Halleck to exclude people from their personal property is to include a disclaimer, some of those people aren't going to do it, and they're going to lose their First Amendment rights. And that's the exact opposite of how the First Amendment normally works. This court normally adopts presumptions and rules that protect the First Amendment. That's set up prophylactic boundaries to ensure that you don't inadvertently lose your rights.
Well, this is a case where there are First Amendment interests on both sides. I mean, just as there may be First Amendment interests in protecting the private speech of government employees, there are also First Amendment interests in enabling citizens to access the important parts of their government.
Right, but
That's what makes these cases hard, is that there are First Amendment interests all over the place.
Well, but the difficulty is, as Justice Jackson said, it is entirely in my client's control whether these pages are used in their individual capacity or their official capacity. So whatever First Amendment interest is on the other side is extraordinarily weak, because all we have to do is put up a disclaimer and their right completely evaporates. So on the one hand, you'd be adopting a rule that every government official in this country runs the risk of inadvertently losing control over their property because they didn't put up a disclaimer. On the other hand, you have a disclaimer, their clients are still blocked, and everything else happens exactly the same.
Thank you, counsel.